Members, we have already formed a quorum. It is also time to start. Please invite the team from the government to join us. Mr. Ronny Tong has written to me saying that he would like to join the subcommittee. Members, any objection? If not, then I would like to welcome Ronny for joining the subcommittee. Sorry, speakers off mic. It was indeed a mistake on the part of my assistant. It doesn't matter. We welcome everybody. Members have the duty to take part in the scrutiny. So for the pro-establishment camp, we welcome your membership.
OK， 咁歡迎政府嘅代表。
I would like to welcome the team from the government for attending today's meeting.
我或者先請原秘書。
Ms. Yuen, please walk us through your paper on the responses to follow-up questions arising from the previous meeting. Paper CB bracket 4685/14-15 Ms. Yuen. Thank you, Mr. Chairman. At the meeting of the subcommittee held last week, members raised certain questions concerning Section 2 of the Competition Turnover Regulation, CTR, in relation to the ordinary activities. Well, for Section 2 of the CTR, in both Sections 1 and 2, we talk about the gross income or gross revenue. And in fact, we have to take away the tax rebates and other things for revenue gained from ordinary activities for Hong Kong entities in accordance with the accounting practices of Hong Kong. We will look at the gross revenue, total gross revenue, and in accordance with the accounting principles, we cover both pecuniary or monetary and non-monetary rewards. If we are to take away the sales rebates and taxes directly related to the revenues, I think this is the usual practice, and you'll find similar provisions in the UK counterpart as well as the Singaporean law. To make it clear, in relation to clarify the drafting of Section 2, we have also made reference to the overseas models. So we are going to propose a new subsection so as to say that we will be adhering to the general accounting practices. In fact, we have got examples set out in the Hong Kong accounting standards as to how to arrive at the revenue. In fact, the Commission, that is the Competition Commission, has already has a communication with the government. We will draw reference from the Hong Kong AS, there is the accounting standards, as well as the concepts generally used by other competition jurisdictions. There will be further guidance on turnover assessment. In our paper, we've set out our intention and as well as our proposed amendment. We have also tabled a marked-up version. I'd like to pause here so that if members have got questions, we can address our concerns. And later on, we can also go through the marked-up copy concerning Section 2 of the CTR. Questions? No questions? Yes, our legal advisor. Thank you, Mr. Chairman. Before the DS goes to the details of the amendment, I think I need to raise a point for members' concern. I think at the previous meeting, members were concerned as to how we define ordinary activities and how the turnover should be calculated. Now, our provision is a bit different from that in the UK model and the Singaporean legislation. Well, in fact, the UK provision and the Singaporean provision have also been given in the government's paper 640/14-15-02. Page 4 of that paper would be of interest.
From the sale of products and the provision of services falling within the undertaking's ordinary activities. 咁而第5頁咧，亦都夾附咗即係新加坡相類似嘅條文啦，都有類。
We have also got the Singaporean model and extraction from the Singaporean model in the paper as well. As to the difference, we talk about the rendering of services as well as the sale of goods. That's important for the definition of turnover. You find them in the legislation in Singapore and the UK, but we haven't got the same here. Ms. Yun, thank you. When we considered our own legislation, as I have said, we have made reference to some overseas legislation. We have also taken into account the local accounting standards. We talk about the source of the revenue. And we talk about the sales rebates as well as the taxes. We talk about the sale of goods and etc. So that's why you can find in the marked up copy, subsection 4 makes it clear that it will be calculated in accordance with the generally accepted accounting principles. In other words, we are sort of incorporating the concept of the Hong Kong AS. Thank you. Mr. Ronny Tong, I would like to thank the legal advisor for raising her point. For the gross revenues, I think the idea is clear under the accounting standards. That is the revenues of the government, other than anything which is one-off or other than anything which is related to the sale of the assets of the company. Gross revenues covers adequately everything needed. If you want to specify that it's about the sale of goods or the rendering of services, I'm afraid you are restricting the definition. And this may be a departure from the spirit of the legislation. So I think I can support the amendment proposed by the government. Legal advisor have raised this point just for members' reference and to enable the government to elaborate on the legislative intent. That is, when we talk about the calculation of turnover, we want to be sure as to what is included and what is not. Ms. Yun, thank you. Indeed, that's our original intention. Ms. Yun, you can carry on. As to the marked-up version already tabled, maybe Mr. Hui can go through it with you. Yes, Mr. Hui. Thank you, Mr. Chairman. If you have got a copy of that paper with you, where can I get a copy? I haven't got the marked-up version. Where can I get it? The clerk will give you a copy. Yes, PS, Mr. Hui, please. I will use the Chinese version of the marked-up copy. There are 2 points. First of all, Section 2(3)(a) is to be amended, and then we would like to have a new subsection that is 2(4). First of all, subsection 3 of Section 2. arising from the meeting of the subcommittee last week. Members have said that under 2.3a we have the term any sum. It was pointed out that the term any sum may cause chaos in interpretation in relation to amounts. We believe that 3A could have been drafted more clearly and concisely so as to avoid having to use the term any sum. And then perhaps in this way we can ease the concern in relation to confusion over the terms. So our proposed amendment is as follows. If we talk about the grant, subsidy, or financial assistance, and I think that will be clear enough, and then we can delete the words any sum by way of any. So whenever we refer to any sum, we dispense with the term the sum or any sum. We just say the grant, subsidy, or financial assistance. I think it will enhance the certainty and clarity of the provision.
Any questions? Legal advisor. Thank you, Chairman. I want to make several points. First of all, well, members were concerned about the calculation of turnover last time. Has the government looked into other countries' examples? That is, how do they calculate ordinary, or how do they look at ordinary activities, and how do they do the relevance calculation? And for 2(4), which is newly added, in other legislations in Hong Kong, do you have a similar provision? That is, when it comes to the calculation of revenue, it must be calculated in accordance with generally accepted accounting principles. Mr. Hui, as for other countries' competition laws, yes, they also talked about turnovers. But it's not so much about the definition of turnover. Now, when a competition entity or when the relevant court decides on pecuniary penalty, the undertaking and the court may have different views concerning the calculation of the pecuniary penalties, which is derived from the turnover. However, as to what constitutes the turnover and the definition of turnover, other jurisdictions also do not attach too much importance to this. So we haven't seen any direct reference that we can draw from. And as for your second question, for the newly added 2(4), we use such a phrase that is calculated in accordance with generally accepted accounting principles. We can also see this phrase in other ordinances. For example, the Communications Ordinance and the Telecommunications Ordinance. In the subsidiary legislation, we also see this type of phrase. That is, for a licensee, is accounting would have to be done in accordance with generally accepted accounting principles. So Now we are suggesting to add 2 brackets 4, and this kind of phrasing can be found in other pieces of legislation in Hong Kong. Mr. Ronny Tong, Chairman, I think this is appropriate. Now we are formulating this regulation because we want to put together a clearer measurement framework. And in the future, when we see actual cases, there will be controversies. So I think the Competition Tribunal would have to look at these issues in accordance with the framework. The government says that certain things would have to be calculated in accordance with generally accepted accounting principles. I have also seen this in other pieces of legislation. I have never encountered any major problems which cannot be resolved. So I think this is an appropriate way of doing it. Okay, other views? Legal advisor. I can supplement. We have looked at similar provisions. For example, Telecommunications Ordinance Section 24 and Cap 562 Section 17 bracket 2. They also have similar phrasings. However, for those provisions, when they talked about accounting principles, they state clearly what accounting principles, although it's phrased as generally accepted accounting principles, when it comes to actual operation, the relevant guidelines that have to be used will be stated clearly. And also, for the generally accepted accounting principles, they are talking about the Hong Kong standards. Here, we don't see any mention of Hong Kong standards. So can the government tell us why? Legal advisor, how about the other 2 ordinances? How do they phrase it? Well, for the Telecommunications Ordinance, Section 7H, it says that the licensee should adopt the authorities' specified accounting principles. It's also mentioned generally accepted principles, but it's that set of principles specified by the authority. For example, it's the Hong Kong Accounting Standard 18. So when it comes to actual operation, the licensees would know what kind of principles they have to follow. As for communication ordinance, they say that it should be in line with the accounting principles that are generally accepted in Hong Kong. So that's why I say that they include the reference to Hong Kong standards. So I want to ask the government why here we do not mention anything about Hong Kong standards. Thank you, Chairman. Legal advisor. The legal advisor mentioned those ordinances. Yes, you are right. The government has also looked into other pieces of legislation in Hong Kong, and now we are adding to bracket 4. We think this is an appropriate way of phrasing it because competition ordinance is quite different from other pieces of Hong Kong legislation. Because for the undertakings that is regulating, these undertakings include Hong Kong undertakings as well as other as overseas undertakings. And these overseas undertakings, if they are not a registered company in Hong Kong, then their accounting principles may not be the same as those in Hong Kong. So for the newly added section of 2 bracket 4, we have to ensure that all the undertakings regulated by the competition ordinance will be covered. So that's why we haven't stated that only Hong Kong accounting principles are applicable. In other words, if that undertaking operates in Macau or on the mainland, then the mainland accounting principles will be used, right? So you have to look at the local standards. Now, the first thing we will look into is whether the accounting procedure is in line with our regulation. For example, whether it covers ordinary activities and whether sales rebates and taxes directly related to the revenues have been deducted. And if these are in line, then when we look at the details, we will be looking at subsection 4, that is generally accepted accounting principles. I would like to thank the legal advisor for his advice. I don't think that a certain set of accounting principles should be stated in the law, because accounting principles change all the time. They would be updated all the time. And if there's an international trend, we would follow. So if you make it so rigid, then in the future you may have to amend it, and you won't be given much room to the tribunal as to what are generally accepted accounting principles. In the law, if there is a foreign company and if it does something in Hong Kong which is unlawful, however, that particular thing is not unlawful in the place where the company is registered, then the Hong Kong court should also refer to the law there. This will give the court more flexibility. As for Hong Kong's accounting principles, as far as I know, they are up to international standards. As for mainland accounting principles, yes, they are different from those of Hong Kong. But as to whether mainland accounting principles are generally accepted in Hong Kong, I don't think so. And I think we should give this flexibility to the tribunal. The tribunal would look at the actual situation of the undertakings involved, and then it will make its consideration. I think that would be more appropriate. I don't think we should make it so rigid here. That is, stating in the law that the accounting principles are those generally accepted in Hong Kong. So this should be handled by the tribunal. That would be more appropriate, because there will not only be one judge at the tribunal. They would also seek the views of accountants and experts of economy. So I think this would be more suitable. It's better than making it so rigid in the law. So, Mr. Tong, according to your legal view, if the word Hong Kong is not stated here, then if that is a Hong Kong company, you will use the Hong Kong accounting principles. I think the court will look at that. If that is a Hong Kong company, the court will definitely look at Hong Kong accounting principles. But if the company does not agree, then it can also put forward its justifications. Okay, any supplement from the government? Legal advisor? No? Do members have any other questions? If not, then we have completed the clause-by-clause examination, and the English version is also fine, right, Legal Advisor? Yes. Okay, so if there are no other questions, then we have completed the scrutiny of these 4 subsidiary legislation. And on the 25th of March, well, we can extend the scrutiny of this piece of legislation, and the notification date is 8th of April. If we are moving any amendments, the deadline is the 15th of April. So I don't think anyone is going to move CSA. Chairman, our plan is that if members agree to the amendments, we hope that at the council meeting on the 15th of April, the government will be proposing the amendments. So can they do that in time? We will serve the notice on the 8th of April, and then we will be doing this. We will be proposing the amendments at the council meeting on the 15th of April. Okay, thank you. Meeting adjourned.